Good evening, friends. We are now discussing about the Arbitration and Conciliation Act 1996. All of you would have heard about a bill recently passed by the Lok Sabha of the Parliament. Of course, I would like to say that it is not a new amendment to the Arbitration and Conciliation Act. This was brought in November 2020 itself by way of an ordinance. All that this particular amendment to section 36 says is that if a court is considering an application to setting aside the arbitral award under section 34, now the court is not bound to grant stay of the enforcement of the award. Of course, court has powers to grant stay subject to such conditions as it may deem fit to impose and for reasons to be recorded in writing on a separate application made for that purpose, saying I want to stay for falana reasons. So these are all the things which were introduced in section 36 previously from 23rd October 2015. Before this amendment, section 36 was a very plain and simple provision saying that if the time limit for making the arbitral making an application for setting aside an arbitral award is over, then the arbitral award is enforceable as if it were a decree. Okay, let us now look at what is the time limit. Time limit is 90 days from the date of receipt of the, it's not 90 days actually, it is 3 months from the date of receipt of the arbitral award by the party who is making the application under section 34 of the Arbitration Conciliation Act 1996 for setting aside the same. Of course, you must be aware that within the 3 months, if an application is made for extending the time for filing the application for setting aside under section 34, another 30 days is available. Therefore, basically we can say 90 plus 30. 90 days and 30 days, 120 days. Now these 120 days are over from the date of receipt of the award. Section 36 kicks in. Section 35 kicks in. Section 35 says finality of the award is reached. Section 36 is as if it were a decree, you can enforce it. Now at the time of enforcement, previously what happens is section 34 itself used to take years together. But because of the amendment to section 34, there is a specific statement in section 34 that the arbitration, the setting aside applications must be disposed of within 1 year. And per se, there is an incentive also. If it is done within 6 months, arbitrators can get more fee as may be decided by the parties, which means it is the purpose is to provide for early closure of the matter, subject matter of dispute, and that's how it was. And just because somebody has filed an application for setting aside under section 34 doesn't mean that it cannot be enforceable. This was the amendment originally brought from 23rd October 2015 to section 35. However, what happens is that invariably parties will make an application for setting aside, whoever is a losing party. Secondly, invariably there will be an application for grant of stay. So these are all the things which we have to remember. And section 34, if you look at carefully, it's not that it's like an appeal against an order of the court in the first round and go to the second round. There are specific grounds. You can't file an application for setting aside an arbitral award just like that. There are specific grounds. They are stated in section 34. One of the grounds in section 34 is, it simply says that the application for setting aside the arbitral award can be made by a party who says who was under some incapacity or who is able to show that the agreement is not valid under the law, which is the subject matter of that particular arbitration agreement. Or the party who is applying for the applicant for setting aside can always show that there was a procedural problem, he was not under notice, the principles of natural justice violator, or for example, he can say the dispute was not contemplated to be resolved through arbitration as per this, because arbitral agreements are basically agreements, and therefore the tribunal cannot travel beyond the scope of the arbitration agreement. Or there could be the question of non-arbitrability of the subject matter, or there could be the question of the other question which is said is the public policy, that the award is opposed to public policy, something like that it can be. For example, somebody says pay X amount to the party to the arbitration now, in the arbitration award to the pay some X amount, and he is a foreign party, and when the particular amount cannot be paid under the conditions of Foreign Exchange Management Act, there are some grounds. You can always say it is a contravention of law if it is enforced. So, opposed to public policy is a very important ground, and the explanation under section 34 very clearly said that if it is shown to the court to which the set-aside application is made that the making of the award was induced or affected by fraud or corruption, it shall be deemed to be a case of opposed to public policy. This is section 34. Now, with that ground in mind, if you look at the amendment to section 36 made by this November 2020 ordinance sought to be regularized by the bill that is recently passed by the Lok Sabha, you will find that there are two grounds actually. Ground number one is, of course, the making of the award was induced or affected by fraud or corruption. It shall stay the award unconditionally pending disposal of the application for set aside. In addition, section 36, this proposed amendment or the amendment made through the ordinance says that if the party is able to satisfy the court on a prima facie basis that the arbitration agreement or contract which is the basis of the award or the making of the award was induced or affected by fraud or corruption, stay is unconditional, automatic, and it is for the until the disposal of the arbitration set aside application. So this is what is the important point we should remember. Of course, there are very highly subjective elements like induced by fraud. You would have already canvassed it before the arbitrator. Corruption, you would have already made objections before the arbitrator that there is a procedural problem, there is a very serious problem. All those things you would have already said. The arbitration tribunal might have probably looked at it, probably disregarded it, probably rejected it for reasons. Because, the corruption charges, fraud elements can also be discovered subsequently because of some other discovery of information. So there could be some arrangements, there could be even a statement of independence given by an arbitrator can be challenged by way of practice which is unethical. We do not know, because subsequently you may say that there was some deal with the arbitrator or something like that. The point is, if it is satisfied in a stay application under section 34, which is filed along with setting aside of the arbitral award, the court is prima facie satisfied that the arbitral agreement or contract, which is the basis of the award, or the making of the award, was induced or affected by fraud or corruption. So there are two grounds. In that two grounds, stay is unconditional. The court shall grant unconditional stay. Otherwise, ordinarily, no stay. Setting aside application filing does not mean section 36 will not kick in. Section 34 may have been filed. No stay is granted. It is enforceable. Award is enforceable. If stay is required to be granted, the party making the application for setting aside must separately make an application, ask for a stay by a separate application. Court, if it wants to grant stay, it can impose such conditions as it may deem fit. For example, it can say the award amount shall be deposited in the court, and it should be recorded in writing why does it grant stay. Therefore, the exception to that rule is unconditional stay can be granted if the court is prima facie satisfied that the agreement or contract which formed the basis of the award or the making of the award was induced or affected by fraud or corruption. That's it. Thank you very much.